Academic freedom is often a contested, misunderstood concept. Faculty academic freedom is a unique dimension of faculty employment status. My name is Crystal Spruill Carter, and I am a doctoral student at the University of Texas, Rio Grande Valley. This training video will analyze what academic freedom is, who has the power, with issues regarding teaching, grading, research, and social media. Faculty academic freedom claims are often First Amendment freedom expression claims. Academic freedom claims may also be based, however, on unique applications of First Amendment free expression principles on constitutional rights other than freedom of expression or on principles of contract law. Neither tenure, nor a particular faculty rank, nor even full-time status is a legal prerequisite for faculty academic freedom claims. Faculty members possess whatever academic freedom is guaranteed them under the faculty contract, either an individual contract or in some cases a collective bargaining agreement. Contract law limits both public and private institutions' authority over their faculty members. Public institutions' authority is also limited by constitutional concepts of academic freedom. The professional concept of academic freedom finds its expression in the professional norms of the academy, which are in turn grounded in academic custom and uses. The most recognized and most generally applicable professional norms are those by the American Association of University Professors, AAUP. Most of the norms appear in the AAUP standards, statements, and reports that are collected in the AAUP policy documents and reports. This publication is called the Red Book. In a series of cases in the 1950s and 60s, the U.S. Supreme Court gave academic freedom constitutional status under the First Amendment freedoms of speech and association, and to a lesser extent under the 14th Amendment guarantee of procedural due process. The opinions in these cases include a number of ringing declarations on the importance of academic freedom. In Squeezy versus New Hampshire, both Chief Justice Warren's plurality opinion and Justice Frankfurter's concurring opinion lauded academic freedom in the course of reversing a contempt judgment against a professor who had refused to answer the state attorney general's questions concerning a lecture delivered at the state university. In Shelton versus Tucker, the court invalidated a state statute that compelled public school and college teachers to reveal all organizational affiliations or contributions for the previous 5 years. In Griswold versus Connecticut, the court majority, in an opinion by Justice Douglas, stated that the state may not, consistently with the spirit of the First Amendment, contract the spectrum of available knowledge. The right of freedom of speech and press includes not only the right to utter or to print, but the right to distribute, the right to receive, the right to read, the freedom of inquiry, freedom of thought, and freedom to teach. The rights of speech and press, in other words, cannot be effectively protected in the college and university environment unless academic freedom as a corollary of free speech and press is also recognized. Kession is the centerpiece of the formative 1950s and 1960s case. The appellates were State University of New York faculty members who refused to sign a certificate stating that they were not and never had been communists. The court held that the faculty members' First Amendment freedom of association had been violated by the existence and application of these series of laws and rules that were both vague and overbroad. 1 year after Kession, the Supreme Court decided Pickering versus Board of Education. and thus stepped gingerly into a new line of cases that would become the basis for the second stage of academic freedom's development in the courts. This line of cases, now called the Pickering-Connick line, or sometimes the Pickering-Connick-Garcetta line, centers on the free speech rights of all public employees, not merely faculty members. There are two paradigms for academic freedom conflicts. They may be either external or internal. The first type of conflict occurs when a government body external to the institution has allegedly impinged upon the institution's academic freedom or that of its faculty. The second type of conflict occurs when the institution or its administrators have allegedly impinged upon the academic freedom of one or more of the institution's faculty members. The means of infringement, the competing interests, and to some extent the applicable law may differ from one type of conflict to the other. The first type is usually controlled by the Keshion line of cases, or by the NTU case that is an offshoot of Pickering-Connick. The second type of conflict is usually controlled by the Pickering-Connick line of cases. Courts are generally reluctant to become involved in academic freedom disputes concerning course content, teaching methods, grading practices, classroom demeanor, and the assignment of instructors to particular courses, viewing these matters are best left to the competence of the educators themselves and the administrators who have primary responsibility over academic affairs. So the question becomes, who has the power? Is it the faculty, the institutions, the courts, or is no one? The key question, yet to be resolved, is whether the courts will analyze the protections for faculty teaching and grading at public institutions by using the dichotomy between employee speech and private citizen speech emphasized in Garcetta, or are the courts going to create an exception from Garcetta for faculty speech relating to teaching? Generally, in the early 1970s, when First Amendment cases about classroom teaching began to arise in significant numbers, the courts assumed a posture of judicial deference to the decisions of higher education administrators and their institutions. So usually, the complaining faculty member received no protection from the courts. In Martin versus Parrish, the court upheld the dismissal of an economic instructor at Midland College in Texas, ruling that the instructor's use of profane language in a college classroom did not fall within the scope of the First Amendment protection. Applying Connick versus Myers, the court held that the instructor's language did not constitute speech on matters of public concern. The court also acknowledged the professor's claim that he had a right to his First Amendment right, but such language was not germane to the subject matter in his class and had no educational function. With Bishop versus Arnault, this continued the trend toward upholding institutional authority over faculty members' classroom conduct, while raising new issues concerning religion and religious speech in the classroom. So, an exercise psychology professor occasionally referred to his religious beliefs during instructional time. So, the professor challenged the university's action as violating both his freedom of speech and his freedom of religion under the First Amendment. So, in short, Dr. Bishop and the university disagreed about a matter of content in the courses he taught. The university must have the final say in such a dispute, the courts ruled. These limits are very important, and regarding the professor's classroom activities, the court clearly stated that the university's authority applies only to the classroom speech of the professor. In DeBona versus Matthews, the court provided a measure of protection for the professor's artistic and literary expression as it relates to the choice of class content and materials. So the court held that San Diego Community College district administrators violated a teacher's free speech rights when they canceled a controversial play production and a drama class in which the play was to be performed. So the play that the instructor had selected was entitled Split Second. It was about a black police officer who, in the course of an arrest, shot a white suspect after the suspect had subjected him to racial slurs and epithets. So this play's theme closely paralleled the facts of a criminal case that was being tried in San Diego. So the court determined that the college administrators had canceled the class because of the content of the play. So while the First Amendment free speech clause did not completely prevent the college from considering the play's content in deciding to cancel the drama class, the court held that the college's particular reasons that the religious community opposed the play and that the subject was controversial and sensitive were not valid reasons under the First Amendment. So in Hardy versus Jefferson Community College, the U.S. Courts of Appeal for the Sixth Circuit held that an adjunct instructor's classroom speech was protected because it was on a matter of public concern and was germane to the subject matter of the course. So the instructor had claimed that the community college's refusal to rehire him violated his rights of freedom of speech and academic freedom. Along with his lecture, he conducted a group exercise in which he asked students to suggest examples of words that historically served the internet interests of the dominant culture. So, the appellate court in this particular case ruled that the instructor's speech was germane to the subject matter of his lecture on the power and effect of language and was limited to an academic discussion of the words in question. So the college had presented no evidence that Hardy's speech had undermined his working relationship with his department or that it interfered with his duties or impaired his discipline. The court's analysis drew upon both the Pickering-Connick line of cases and the germaneness approach to faculty academic freedom. Grading is an extension of the teaching methods that faculty members use in a classroom. Just as courts are reluctant to intervene in disputes regarding a classroom, courts are hesitant to intervene in grading disputes among professors. While the administration usually prevails when a court rules on such disputes, there are circumstances in which faculty members may occasionally prevail. So in general, the Lovelace versus Southeastern Massachusetts University case, the court upheld institutional authority over grading in much the same way that other courts had done in classrooms. The university had declined to renew a faculty member's contract after he had rejected administration requests to lower the academic standards he used in grading his students. So the faculty member claimed that the university's actions violated his free speech rights. The court rejected the professor's claim because the university itself had the freedom to set its own grading standards, and the First Amendment does not require that each non-tenured professor be made sovereign unto himself. So when a dispute concerns an individual grade rather than general grading policies, however, different considerations are involved that may lead some courts to provide limited protection for the faculty member who is assigning the grade. So the case of Pirate versus Isabor provides an example of this. So the defendant, the dean of the school in which the plaintiff was a non-tenured professor, ordered the plaintiff over his objectives to execute a grade change form, raising the final grade of one of the students. So the plaintiff argued that this and several later incidences alleged to be retaliation for the lack of cooperation regarding the grade change violated his First Amendment academic freedom. So relying on the free speech clause, the court agreed that because the assignment of a letter grade is symbolic communication intending to send a specific message to the student, the individual professor's communicative act is entitled to some measure of First Amendment protection. However, the court did indicate had the university administrators changed the students' grade themselves, this action would not have violated the plaintiff's First Amendment rights. So in the Armady court, they declined to follow the pirate and instead applied its own prior case of Edwards versus California University of Pennsylvania. So the court drew from Edwards the position that in the classroom, the university was the speaker and the professor was the agent of the university for First Amendment purposes. So, using this university as speaker theory, the Edwards Court had asserted that as the university's agent or proxy, the professor in the classroom fulfills one of the university's four essential freedoms set out in the Frankfurt concurring opinion in Sweezy versus New Hampshire. So, thus, the court relied on the reasoning that because grading is pedagogic, the assignment of the grade is subsumed under one of those four essential freedoms, the university's freedom to determine how a course is to be taught. And since this freedom is the university's and not the professor does not have a First Amendment right to expression via the school's grade assignment procedures. As a matter of policy, academic freedom protections clearly extend to the research and publication activities of faculty members. Such activities are apparently the most urgently protected of all faculty activities. In the 1940 Statement of Principles on Academic Freedom and Tenure, full freedom in research and in the publication of the results is presented as the first of three essential aspects of faculty academic freedom. The case of Levin versus Harrelson discussed illustrates the broad protection for faculty research and publication. So, with Levin versus Harrelson, it affirmed in part and vacated in part, involves a faculty member's publication of controversial views and features the application of classical First Amendment and academic freedom principles. So, a philosophy professor at City College of the City University of New York had opined in certain writings and publications that black people are less intelligent on average than white people. In addition, he had opposed all use of affirmative action quotas. So the professor sought declaratory and injunctive relief, claiming that the creation of a shadow section and the operation of an ad hoc committee violated his rights under the federal Constitution's free speech and due process clauses. So, to determine whether this infringement on the professor's speech was legitimate, the court undertook a Pickering-Connick analysis. It held that there was no question that the professor's speech was protected expression, since his writings and statements addressed matters that were quintessentially issues of public importance. Levin is an important case for several reasons. It painstakingly chronicles a major academic freedom dispute centering on faculty publication activities. It demonstrates a relationship between academic freedom and the phenomenon of political correctness, and it strongly supports faculty academic freedom in research by using the federal Constitution as a basic source of protection. Does academic freedom have what it takes to protect us as technology changes and social media exercises such powerful control on communication? The AAUP provides guidance for what is going too far. The controlling principle is that a faculty member's expression of opinion as a citizen cannot constitute grounds for dismissal unless it clearly demonstrates the faculty member's unfitness for his or her position. So, although they uphold the right of faculty to make these extramural utterances, these guidelines actually restricted faculty members' freedom as a mere citizen, imposing restrictions that the AAUP believe are appropriate for the special role of a member of the professorate. Faculty members, therefore, are bound by expectations established not by the institution but rather by the principles of the organization set up to protect academic freedom. When we ask how institutions have the audacity to monitor the extramural utterances of faculty members, a good place to start is the principle that addresses and apparently sanctions these comments. There is no doubt that institutions are involved with and concerned about the extramural utterances of their faculty. Why wouldn't they be? After all, the guidelines acknowledge the stake that institutions have in these utterances. Because of their important and powerful constituents, universities seek control of their image, message, and reputation, and how they affect current and potential students and their families, alumni, donor base, community leaders, and state legislators. A misstep can bring harm to years of carefully cultivated work, Naturally, they want to avoid such a prospect. Universities, therefore, are concerned about what members of their community say about them on social media. However, as Whittington noted, an institution's brand should take account of the fact that colleges and universities are places where people voice controversial ideas, where competing ideas are welcome, and where ideas can be fearlessly debated, defended, and rejected. The question is not whether institutions have an interest in the social media contributions of faculty members, but rather whether they have a right to exercise control of them. Therein lies the problem. Actually, the AAUP provides guidance for what is going too far. The controlling principle is that a faculty member's expression of opinion as a citizen cannot constitute grounds for dismissal unless it clearly demonstrates the faculty member's unfitness for his or her position. But we sincerely ask, what constitutes unfitness? Is it sufficient that a faculty member's expressions disagree with what is considered to be the orthodox or his or her campus? Is it enough that a faculty member expresses his or her views in an uncivil or rude manner? Or is behavior that is obscene or difficult to define, but we know it when we see it? Academic freedom scholar Whittington noted, no doubt professors sometimes behave irresponsibly in public or voice ill considerations, mistaken, or even disgusted opinions, but nonetheless, institutions of higher education would be worse off if they regularly sought to censor such speech by members of the faculty. So, in fact, deviation from orthodoxy seems to play a role in what institutions find acceptable. So, many readers will recognize the case of Stephen Salidia, whose job offer at the University of Illinois was rescinded when he sent out tweets critical of Israel. Because that political perspective was not acceptable to his new university, officials withdrew the job offer, commenting that his views would make it difficult or impossible for him to have civil conversations with those who disagreed with him. There are other cases as well, such as the faculty member who blogged about her support of same sex marriage, which was not an acceptable view at the university where she taught. Her online comments cost her continuing employment. In another case, a faculty member at Duke University spoke about how his views on group integrating into American society, when he said online that he believed Asians have integrated into American society more effectively than African Americans. A Duke spokesperson said that the professor's comments were obnoxious, offensive, and have no place in civil discourse. Of course, great importance, however, is the fact that whereas the faculty member's remarks were offensive, the university still recognized his right to make them. What about the issue of a faculty member being rude, controversial, or vulgar? Do these qualities prove an unfitness to teach? Situations involving John McAdams of Marquette University, posted online a conversation between a graduate and an undergraduate student on this topic of same-sex marriage, identifying the individuals involved. Professor McAdams was dismissed by the university. However, he took the matter to court, and after lengthy litigation, he won his case against the university and was reinstated in 2018. In the interest of academic freedom, this training video covered the basic concepts and rights of faculty academic freedom, what it is, who has the power in the classroom, grading, research, and on social media, the importance of foundational constitutional law cases, and external versus internal restraints. Read more on the subject matter with the literature in the reference section. Again, my name is Crystal Spruill Carter. Continue the conversation on social media. Follow me at Crystal S. Carter on Twitter, Instagram, and Facebook.